So in this session, we are going to learn effects of registration under Section 9 of Companies Act 2013. The Section 9 of the Act provides for the effect of registration of a company. It states from the date of incorporation specified in the Certificate of Incorporation, the subscribers to the memorandum and all the persons who may become members of such company and shall be a body corporate by the name as contained in the memorandum. So what happened from the date of incorporation, which is mentioned in the certificate of incorporation, all the subscribers who are previously were the subscribers who signed to the subscriber of the signed to the memorandum on and articles of association will become members of such company, and that company shall be a body corporate by the name as may contain in the memorandum. Now, thereafter, such body corporate by the said name shall be capable of exercising all functions of an incorporated company. They under this act and having a perpetual succession means it continues forever. It never dies, and it gave the power to acquire, hold, and dispose of property, both tangible, intangible, and movable and immovable, or and to contract and to sue and be sued. Now, summary of Section 9: subscriber to the memorandum and all other person who may from time to time become the members of the company. Registration, certificate of incorporation granted from the date of incorporation specified in the certificate of incorporation becomes a body corporate by the name specified in the memorandum. Now, under the said name, exercising all the functions of an incorporated company, power to acquire, hold, and dispose of property, whether movable or immovable, whether tangible or intangible. Then it get the power to contract or to sue or be sued, and having perpetual succession. These are the effects of a company after registration. Under Section 7, we register the company, and after under Section 9, we get these effects of registration. Now, we will see the Memorandum of Association under Section 4 of the Companies Act. What is meant by Memorandum of Association? It is the fundamental document for the formation of the company. Hence, consider as it's a charter or constitution. Memorandum defines the relationship of the company with outsiders because it enables all those who deals with a company to know what its powers are and what activities it can engage in. The memorandum shall contain the following clauses: name clause, situation clause, also called as register office clause, then object clause, liability clause, capital clause, association clause, nomination clause. Capital clause applicable if companies formed with share capital, and association clause or subscription clause specifically drafted in case of OPC, and nomination clause applicable in case of OPC. Now, Section 4 of the Act, along with relevant rules from the Companies Incorporation Rules 2014, provides for the requirement with respect to memorandum. Name clause. Section 4, subsection 1, read clause A, read with subsection 2 to 5. The name of the company with the last word limited in case of public company or private limited in case of private limited company. The above clause is not applicable in case of Section 8 companies, because for Section 8 company, which is a licensed company which get license from government to perform charitable objects, it doesn't need to use suffix such as limited or private limited. Okay, now in case of specified IFC or public company or IFC private company, name shall have the suffix International Financial Service Center or IFSC. Application for reserving name for proposed company, subsection 4. The Section 4, subsection 4 tell that a person may Make an application in Spice Plus that is simplified pro forma for incorporating company electronically plus INC 32 accompanied by fee as provided in the company's registration offices and fees rules 2014 to the registrar for the reservation of the name set out in the application as name of the proposed company. Resubmission shall be allowed within 15 days for rectification of defect if any. Application for reserving the name for the changing name of existing company, subsection 4. A person may make an application using web service that is run RUN, reserve unique name, along with a fee as provided in the company's registration offices and fees rules 2014 to the registrar for the reservation of the name set out in the application as the name to which the company proposes to change its name. And resubmission shall be allowed within 15 days for rectification of defect, if any. Restriction regarding names and use of words and expression therein. Subsection 2 and 3 of Section 4 states that the name mentioned in the memorandum shall not be identical or resemble too nearly to the name of an existing company registered under this Act or any previous company law, or such use of which by the company will constitute an offense under any law for the time being in force, or use of such use of which by the company is undesirable in the opinion of central government. This power of central government has been delegated to ROC. Further, subsection 3 provides, unless the previous approval of the central government has been obtained, a company shall not be registered with that name, which contains any word or expression that is likely to give the impression that the company is in any way connected with or having a patronage of the central government or any state government or any local authority or corporation or body constituted by central government or any state government under any law for the time being in force, or which includes words or expression, namely board, commission, authority, undertaking, national, union, central, federal, republic, president, Rashtrapati, small scale industries, Adi and village industry corporation, financial corporation, and the like, municipal development authority, prime minister or chief minister or minister, nation, forest corporation, development scheme, the statute and statutory, court or judiciary, governor, bureau, and the use of the word scheme with the name of the governments or state, India, state, India, Bharat, or any government authority, or any manner resembling with the schemes launched by central, state, or local governments and authorities. A name is said to be resemble when difference is only and only of plural or singular forms of words in one or both names, like Green Technology Limited is named as Greens Technology Limited or Greens Technologies Limited, and type and case of letters, spacing between letters and punctuation marks used in one or both names. For example, ABC Limited is same as A dot B dot C dot limited or A space B space C space limited. Use of different tenses in one or both names, as in private Ascent Solutions Limited is same as Ascended Solution Limited or Ascending Solution Limited. Slight variation in the spelling of two names, including a grammatical variation thereof. For example, Disk Solution Limited is same as Disk Solutions Limited, but it is not same as Disco Solutions Limited. Because here they have changed a single letter P to A, but here addition of letter. So this is available, but this is allowed, but this is not allowed. Use of different phonetic spellings, including use of misspelled words of an expression. For example, BW KY Limited is same as BK Limited, and BK Limited or BK Limited, PK Limited, or BK B dot K Limited or BK Limited. These are of similar nature. complete translation and transliteration and not part thereof of any existing name in Hindi or English. For example, National Electric Corporation Limited is same as Rashtriya Vidyut Nigam Limited. Use of host name such as www or domain extensions such as .net, .org, .com, .com in one or both names. Ultra Solution Limited is same as Ultra Solution.com Limited, but Supreme Ultra Solutions Limited is not same as ultrasonic.com Limited. Okay, now the order of words in the names Ravi Builders and Contractors Limited is same as Ravi Contractors and Builders Limited. The order has been changed. It would be different. Then use of the definite or indefinite articles in one or both cases with both names. Congenial Tours Limited is same as a Congenial Tours Limited. Here they have used an article, definite or indefinite article. They use a. So this is also not allowed. Or the Congenial Tours Limited. But Isha Industries Limited is not same as an Anisha Industries Limited because this is not an article. Addition of the name of a place to an existing name which does not contain the name of any place. If Salvage Technologies Limited is an existing name, then it is same as the Salvage Technologies Delhi Limited. Here they have said that addition name of any place to an existing name which does not contain the name of any place. For example, if Salvage Technologies Limited is an existing name, then it is same as Salvage Technologies Delhi Limited. But Retro Pharmaceutical Ranchi Limited is not same as Retro Pharmaceuticals Chennai Limited. Because there was if already there is a name of place and then you are using the name of another place, then it is okay. But at the initial there is no space of name in the name of the company, and you are using adding the name of the place in that the former one, then it would be the violation. Addition, deletion, and modification of numerals or expression denoting numerals in existing name unless the numerals represents any brand. For example, Thunder Services Limited is same as Thunder 11 Services Limited or One Thunder Services Limited. Now, student may also refers to the 23 instances specified in Rule 88 of the Companies Incorporation Rules 2014 that can amount to undesirable names. So, Rule 80A of the Companies Incorporation that can amount to undesirable names. So, Rule 81 describes the undesirable name. Now, reservation of name, subsection 5. Now, upon receipt of an application, the registrar may, on the basis of the information and the documents furnished along with the application, reserve the name for the period of 20 days from the date of approval or such other period, provided that in case of an application for reservation of a name or for change of the name by existing company, the registrar may reserve the name for a period of 60 days from the date of approval. While allotting names, the registration of companies concerned should exercise due care to ensure that the names are not in contravention of the provisions of the emblems and names, Prevention of Improper Use Act 1950. It is necessary that the registrar are fully familiar with the provisions of the said Act. An application of the extension of reservation of name under Rule 9A of the Companies Incorporation Rule 2014 can be made before expiry of 20 days. Up for another 20 days or total of 40 days with a fee of rupees 1,000, which may be further extended by another 20 days, a total of 60 days with a fee of rupees 2,000. Or for another 40 days, total of 60 days with a fee of rupees 3,000. Now, cancellation of reserved name, subsection 5, where after reservation of name, it is found that the name was applied by furnishing wrong or incorrect information, then if the company has not been incorporated, the reserved name shall be cancelled and the person who has made the application shall be liable to a penalty which may extend to 1 lakh rupees. If the company has been incorporated, the registrar may, after giving the company an opportunity of being heard, either direct the company to change its name within a period of 3 months after passing an ordinary resolution and taking an action for striking of the name of the company from registrar of the companies, or make a petition for winding up of the company. Here, Mr. Anil Desai has applied for the reservation of a company name with the prefix Sanvaria. He claimed that the prefix Sanvaria is registered trademark in his name. Later on, it found that the said prefix is not registered with Mr. Anil Desai. However, he has been he has formed company by giving the incorrect documents or information while applying the name of the company. In such case, the registrar shall take action as per the provisions of the Act after giving opportunity of being heard. Situation clause, section 4, subsection 1, clause B. Section 4, subsection 1, clause B requires the memorandum of a company shall mention the name of the state where the register office is proposed to be situated. The situation, place, or register office is important from perspective of establishing the domicile of a company for the purpose of determining jurisdiction in context to compliance, ROC, RD, etc. Judicial aspect, bench of NCLT, High Court, etc. Fiscal aspect, taxation, and more for more many other purposes. Place at which the company's statutory books must be normally be kept in case of public company, and general meeting also required to be conducted at the register office or in the city where it is situated. Act as the address to which notices or other communication can be sent. So these three benefits, three perspective are there for the situation of the register office. First one, establishing a domicile. Second is place at which the company's statutory books must be normally kept and act as an address which to which notices and to be other communication can be sent. So we need to understand this DSC. First one is establishing the domicile, then the place at which company statutory books to be maintained normally must normally be kept. In case of public company, general meeting also required to be conducted at the register office. So if I have to conduct a general meeting, then it has to be conducted at register office and statutory books to be kept over there. Then the communication for communication notices and other communication can be sent on that address. A company shall, within a 30 days of its incorporation and at all times thereafter, have a register office capable of receiving and acknowledging all communication and notices as may be addressed to it. Object clause, Doctrine of Ultra-Vires. Section 4, subsection 1, clause C requires the memorandum of a company shall state the objects for which the company is proposed to be incorporated and any matter considered necessary in furtherance thereof. So, in the object clause, company has to mention its objects for which the company is proposed to be incorporated and matters considered necessary in furtherance thereof. Specified IFSC public company, IFC private company shall state its object to do financial service activities as permitted under Special Economic Zones, SEZ Act 2005, rate with SEZ Rules 2006, and any matters considered necessary in furtherance thereof in accordance with license to operate from International Financial Services Center located in an approved multi-services special economic zone granted by the RBI, SEBI, or IRDA. A company can't depart away to do anything beyond or outside its object stated in the memorandum, and if any act done beyond that will be ultra-vires and void. Same can be ratified even by the assent of the whole body of the shareholder. Acts ultra-vires to the authority of the directors may be ratified by the company. Articles provided for regulations inside the scope established by MoA. Hence, the acts beyond ultra-vires, the articles can be ratified by the shareholders and provided the relevant provisions are not beyond the memorandum. To illustrate, one of the director is authorized to issue check of rupees 10,000, but he issued for rupees 12,000, then company can ratify him. It is worth nothing here that memorandum of a company can be altered to widen the scope of objects, but such alteration shall have prospective effect only, not the retrospective. Hence, an act once ultra-vires remains so ever. A company may do anything which is incidental to or consequential upon the objects specified, and such act will not be an ultra-vires act. To illustrate for trade, one have rent or own a building, issue invoices, make and receive payments. Essence of doctrine of ultra-vires, then initiation of doctrine of ultra-vires we will see. Let's see. Essence of doctrine of ultra-vires. The doctrine of ultra-vires is meant to protect shareholders and creditors of the company or anyone who deals with the company. So who are the external parties? Their interest has been protected through the doctrine of ultra-vires. For example, initiation of the shareholders and the kingdom. The initiation of doctrine of ultra-vires. The doctrine of ultra-vires was first initiated by the House of Lords in a classic case, Ashbury Railway. So this case you need to understand. Ashbury Railways Carriage and Iron Company Limited versus Rich. Okay. The memorandum of the company in the said case define its objectives. Thus, the objects for which the company is established are to make and sell or lend or hire railway plants, to carry on business of mechanical engineers and general contractors. The company entered into the contract with Messrs. Messrs. Riche, a firm of railway contractors, to finance the construction of a railway line in Belgium. On subsequent repetition of this contract by the company on the ground of its being ultra-vires, the Ritchie brought a case for damages on the ground of breach of contract, as according to him, the words general contractors in the object clause gave power to the company to enter into such a contract, and therefore it was within the powers of the company, more so because of the contract was ratified by a majority of shareholders. The House of the Lords felt that the contract was ultra-vires the company and therefore null and void. The term general contractor was interpreted to indicate as making generally of such contracts as are connected with the business of mechanical engineers. The court held that if every shareholder of the company had been in the room and had said that is a contract which we desire to make, which we authorize the directors to make, still it would be ultra-vires and null and void. The shareholders cannot ratify such a contract as the contract was ultra-vires the object clause, which by the Act of Parliament they were prohibited from doing. Effects of doctrine of ultra-vires. The key effect will be as under. Whenever an ultra-vires act has been or is about to be undertaken, any member of the company can give an injunction to restrain it from proceeding with it. Neither party, even outsider, can sue for enforcement of a specific performance of such agreement. Reasons explains under heading constructive notice. Here, liability clause. Section 4, subsection 1, clause D requires the memorandum of a company shall state, in the case of company limited by share, the liability of its member is limited to the amount unpaid, if any, on the shares held by them. And in case of a company limited by guarantee, the amount up to which each member undertakes to contribute to the assets of the company in the event of its being wound up, while he is a member or within 1 year after he ceases to be a member, for the payment of the debts and liability of the company or of such debts and the liability as may have been contracted before he ceases to be a member, as the case may be, to the cost and charges and expenses of winding up. So this is important. If he is a member or within 1 year after he ceases to be a member. If he is a member and within 1 year. And for the contracted, he as may have been contracted before he ceases to be the member, as the case may be. to the cost, charges, and expenses of winding up, and for adjusting of the rights of the contributors among themselves. Now, those shareholders who are members of the company at the time of its winding up are included in the list A. They are primarily liable for making payment to the company at the time of its winding up. While list B consists of those persons who were the member of the company during the 12 months preceding the date of winding up. B list contributors are liable to contribute if the amount realized from the contributors of list A is not sufficient to discharge the liabilities of the company. Modern Furniture Limited, a company limited by shares having share capital divided into shares with a fixed value of rupees 10 each out of which rupees 8 called up Mr. Singh, who is having 200 shares, paid all rupees 8 on each of the shares he hold, while Ms. Sarla, owning 100 shares, paid rupees 10, rupee 2 in advance, whereas Mr. Sanju, owning 250 shares, paid rupees 6 per shares and rupees 2 in arrears per share. Liability of Mr. Singh, Ms. Sarla, and Mr. Sanju shall be maximum of 2 rupees 400 need and rupees 100 only respectively. That's clear. Now, section 4, subsection 1, clause E, subclause 1 requires in case of the company having a share capital, the memorandum of a company shall state the amount of share capital with which the company is to be registered, usually termed as authorized or nominal capital, and division of thereof into shares of a fixed sum of face value and the number of shares, and the number of shares which the subscriber to the memorandum agrees to subscribe, which shall not be less than 1 share. Subscription clause. Section 4, subsection 1, clause E, subclause 2 requires the memorandum of a company shall state the number of shares each subscriber to the memorandum intends to take indicated opposite his name in case of the company having share capital. Nomination clause. Only in case of one-person company, section 4, subsection 1, clause F requires the memorandum of a company shall state the name of the person nominee who, in the event of death of the subscriber, shall become a member of the company, and in the case of OPC only. This provision is corresponding to the first proviso to section 3, subsection 1, already discussed in earlier chapter. Forms and schedule related to the memorandum, that is subsection C. So there is the memorandum of company shall in the respective forms specified in table E, table B, C, D, E, and in schedule 1 of the Act as the case shown in figure. So what we have to do is memorandum of association of company limited by share, company limited by share, company limited by guarantee, company unlimited. Here, the company limited by guarantee, table number E for this one. Then this limited by guarantee divided into two, not having share capital and having share capital. For not having share capital, table B should be used for memorandum, and with having share capital, C should be used. Unlimited company, 2, not having share capital and having share capital. So here D and here E. But for memorandum of association and for articles of association, table number would be E, F, J, I, E, A, B, C, D, E, G, H, F, here G, H, I, and J. Okay, this should be the format. Now, as per section 399 of the Act, a memorandum is a public document. Consequently, every person entering into the contract with the company is presumed to have a knowledge of the condition contained therein. As per section 4, subsection 7, any provision in the memorandum or articles in the case of a company limited by guarantee and not having a share capital shall not give any person a right to participate in the divisible profits of the company otherwise than as a member. If the contrary is done, it shall be void. Now we will see the articles of association in our next video.